20 days after the Supreme Court declined to nullify the election of Uhuru Kenyatta for a second time, the judges gave their detailed reasons why they had dismissed the petitions filed by Njonjo Mue, Khelef Khalifa and Harun Mwau. There had been 8 issues for the judges to determine, one being whether the withdrawal of then NASA presidential candidate Raila Odinga required that IEBC should stop the elections and conduct fresh nominations. The judges agreed that while Odinga had every right to withdraw from the contest, IEBC was not obligated to conduct a fresh nomination. They have disagreed with IEBC that a candidate who wants to withdraw must do so within 3 days of nomination,
as one cannot be forced to participate in an election in which he or she has lost interest. The NASA candidate, in our view, not only made a public announcement of his decision to withdraw from the elections, but addressed a formal letter to that effect to the first respondent. Such action, in our perception, constituted a substantive and legally effective withdrawal from the elections.
Another matter for the judges to determine was whether, because the election was not held in 25 constituencies, then the election should be nullified. The judges pointed out that IEBC had demonstrated that it had done all it could to provide the election material, but its staff was prevented from accessing the polling stations and therefore was not the one to blame.
There is a low threshold placed upon the Commission in exercising its discretion to postpone an election. Mere apprehension of the breach of peace may trigger the exercise of this power. In the instant case, it was actual and not imagined threat of violence in the affected areas. Therefore, the Commission's actions were not outside the contemplation of the law.
It is our finding that neither the state nor the IEBC bears responsibility for failure of voting in certain areas of the country. Such failure could be attributed to unidentified private citizens and political actors who actively caused the offending situations directly or indirectly.
If we were to hold otherwise, the authority of the Constitution would be surrendered to cynical acts of violence. All one would need to do is to instigate violence in any corner of the Republic during the presidential election and thereafter petition this court to nullify the election. Those who intentionally instigate and perpetrate violence must not plead the same violence as a ground for nullifying an election.
The judges have dismissed the claims by the 3 petitioners that the October election was marred with numerous illegalities and irregularities. They say that none of this was proven to have affected the outcome of the election substantially. Issues such as the low voter turnout have also been dismissed as not affecting the credibility or legitimacy of the election.
An election cannot be tainted solely on the ground of lower voter turnout. This is because of, as we have found, voter fatigue and the general apathy that attends to repeat elections or by-elections. The factors that led to lower voter turnout, although politically tainted, and inviting political solutions are not sufficient in the instance case as a basis for banning the general election.
Not every irregularity or procedural infraction is enough to invalidate an election. The irregularities must be of such a profound nature as to affect the actual result or the integrity of an election for a court of law to nullify the same.
The detailed judgment has revealed that the judges agreed with the petitioners only on one issue, their right to file a petition before the Supreme Court, a matter that had been challenged by the respondents who had said that they were not doing it for the public interest. Andrew Ochieng, NTV.